January 28th is Data Protection Day. So, in this special episode, we bring to you the key messages from different industry leaders, privacy leaders who have been part of this podcast, the Fit for Privacy podcast, in different episodes. So, welcome to this special episode, and my name is Punit Bhatia. I help you to make privacy compliance simple. As we get started, do remember that the opinions, ideas, and thoughts mentioned in this podcast are not legal advice. Should you need legal advice, you should consult a professional with your specific situation. Let's start by hearing from our first episode, wherein Nicola Fabiano, the president of San Marino's Data Protection Authority, told us about how GDPR applies in context of a pandemic.
Thank you for this question. Uh, Unfortunately, we are living in a pandemic time because of the coronavirus or COVID-19. But there is not an exemption related to the processing of personal data. Data protection laws apply anyway. Let me take the opportunity to clarify that the GDPR also applies during a pandemic time, according to Article 9, letter I. I prefer do not go in deep also because there are some other articles which can refer to.
Yeah.
Our first thought goes to data concerning health because doctor, nurses, and health operators take care of patients hence they process most sensitive information, exactly how it was before the pandemic.
Right.
People from the health sector are obliged to process personal data respecting the GDPR or national data protection laws. There are situations where, especially for data concerning health, doctor, nurses, and health operators process personal data which mean to process most sensitive information. So, what would that have changed now? Regarding the healthcare side, maybe the amount of personal data and people to whom they are communicated or shared. Outside the healthcare side, there is no reason to do not apply the GDPR. Those, as I already say, the GDPR applies anyway.
Yeah.
Perhaps, perhaps, especially in this pandemic time, we have to pay more attention to the processing of personal data. Also regarding the development of apps to trace people with the purposes to avoid infection and contain the widespread of the outbreak. Let me take the opportunity to recall some official statements on the impact of COVID-19 issued by the ADPB, European Data Protection Board, and by the Council of Europe.
In episode 2, we had Eileen Shivo, senior privacy analyst, sharing her views on AI and GDPR.
So there are two types of stakeholders you can talk to, let's say, and they will have two different stories to tell. Well, just to exaggerate a little bit the trait, policymakers would say the GDPR, at least in the EU, would be a golden standard, and that it's quite successful. It's been quite successful as being there for future technologies as well, including AI robotics. And industry would tell you a different story. Not all of them may come forth with that, but it has had an impact in the development of AI systems.
Yeah.
I think I briefly hinted at that earlier, is that you have some requirements like data minimization and transparency and explainability, which are basically a tall order when it comes to AI systems. So a lot of companies find it difficult to comply with it and to navigate the complexity of it all, of the requirements.
In episode 3, we had Rob Masson, the CEO of DPO Center, sharing his views on the DPO role and the EU GDPR.
We're taking on the responsibility, or day-to-day responsibility, for the data protection officer role, and we are helping that organisation first off to understand their data and the steps they need to take to comply, and then helping them to implement an appropriate compliance framework and to manage it on an ongoing basis.
Right. So it's for the companies who need a DPO but maybe don't need it full time.
I mean, that's predominantly what it's there for.
Yeah.
Yeah. I mean, I think there's a lot of organisations. The GDPR has brought down the bar in terms of where the cut-off point is for an organisation needing a DPO. It's far from black and white because there's this concept of large scale, but in most cases it's reasonably obvious. And so that bar has been brought down, meaning that more organisations now need to appoint that DPO. But of course, exactly as you say, they don't need to be full-time or even part-time.
Right.
Now, a lot of organisations tend to job share, so they would tend to assign somebody within the organisation who has an alternative role to be the DPO. But of course, the GDPR has, along with it, the obligations for the role. It means that you must avoid a conflict of interest. So it's quite difficult to find somebody in an organisation who is both senior enough to have the responsibility of the data protection officer role, but not so senior that they are then deemed to be in a conflict with effectively their fiduciary duties to represent the needs of the organisation. So outsourcing the role is actually ideal because you get access to a third-party individual who isn't subject to the conflict of interest. But also you get someone who is potentially more experienced, has a wide level of experience. In episode 4, we had Jodie Daniels, CEO and privacy consultant at the Red Clover Advisors, and I asked her.
I work with a lot of marketing companies. Typically, the marketing companies I have seen, especially with social media and online, they have a huge mailing list or a database of emails. And previously, before GDPR at least, what I remember is they tell me that they're used to buying data from one another. So how do you recommend, or what do you tell them in terms of compliance in function of their own mailing lists, and also the aspect which for them it's pretty natural because you have a database and you want to leverage others' database as well. So what do you tell them to comply?
So they don't always love my answer, but I don't really recommend buying a list these days. And honestly, I work with a lot of marketers, and a lot of marketers also don't recommend buying a list. And the reason that marketers don't recommend buying a list is because it's generally not good quality data. From a privacy point of view, you're putting yourself at significant risk because you either A, have to make sure that I've disclosed when I contact you, hi, I got your information from blah, 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 so that you can comply with Article 14, or you have to make sure that the consent was received from the initial company that got it and sold it to you. So there's a lot of risk that's involved in that. You can do it, absolutely. You just have to make sure that, again, you've received the proper approval to send that message, and you need to disclose to the person how you got that information and make sure that you can opt out and have the privacy notice. So if you get all that covered, you're able to proceed. But the marketers generally don't actually get good quality results from buying a list. So I prefer to tell companies, instead of doing that, which doesn't generally yield you a lot, and especially when you compare the kind of cost benefit to cost ratio, that you put that energy and effort and money into something else that nurture your existing list. Buy ads on social media that you can then create a first-party relationship with, right? So there's a variety, attend shows. There's a variety of ways to create that first-party relationship.
In episode 5, I myself talked about GDPR and its challenges.
GDPR takes a framework approach, and a framework approach requires interpretation and application of the principles around which processing of personal data is to be based. This is at times very annoying because some of us expect binary inputs, clear guidance, clear input on this is doable and that is not doable. But when we take a principle-based approach, we get into questions like, can soft delete be considered deletion? What should be the basis of marketing? Should it be Legitimate interest, should it be consent or should it be something else? And the law, by default or by the way it's designed, requires us to interpret these things. And interpretation is never easy because it requires a deep understanding of the law. And this has challenged everyone, no matter who we are talking about.
In episode 6, Daniel Jacobs, the CEO of Beltug, shared with us how GDPR is helping and how GDPR is being beneficial to companies.
As the GDPR is a regulation, it applies directly in all EU members, so that is common knowledge. But what we see now, and that is very interesting, we feel, is that GDPR is also setting the standards for comparable legal initiatives outside Europe. If you see it's happening in California or even in Brazil. We have in Belgium about 60% of our members that work at an international level. And so for them, it's very important to see that what are the possibilities, where can you cooperate or work in the same way in different countries, and what about the rest of the world, because Europe is just Europe and not everything. So that's about the extended scope and the increased harmonization. What is very important, I think, is that because of the GDPR, what we see is that now companies know privacy is important. That is a very, very big difference than what it was 2 years ago.
Right.
So that's a major difference. So the most companies are now more aware, and we get now more and more questions from our CIOs, for example, to say how can we explain to our boards how important the privacy protection is, not only for the fines but also for the image of the company. So you see the knowledge, the awareness is much bigger than it used to be, and I think that is very important as we all deal. Well, we are in a data economy, so that's a very positive point. What also is interesting is that we see now more and more that data protection becomes a kind of sales argument. So no, but it's true. It becomes a competitive advantage.
Absolutely.
That's a very a big advantage of what. Although we complain a lot in our privacy council about this GDPR. It's difficult and it's a lot of work.
Right.
But at the other hand, you see that it is an advantage that we have this kind of privacy regulation as well, because it really brought data protection as a mainstream discussion topic.
In episode 7, we had Dr. Anne Cavaquion, the creator of Privacy by Design. We asked her how to make privacy by design actionable or implementable.
It is eminently actionable, and it relates to the first time you collect personal information from your customers. So let's take one case. You're collecting information from John Doe, and it's for a particular purpose that John has consented to. You have that data, you use it for the intended purpose, all good. Theoretically, that should be the end of the story, unless you have additional consent to use that information for other purposes. You shouldn't be. The reality is, once information is in a company, often it is used within the company and it goes to different departments, different purposes. So the first thing I tell companies is, do you have a data map? Nobody has a data. And I say, that's what you need to form, a data map, so you can navigate all of the different places. You can track where personal information collected for one purpose, if it's going to additional departments and uses for secondary uses that were never intended. So once you have a data map, you can navigate the flow of the information, and you can determine if you need additional consent for secondary usage. It's eminently doable, privacy by design. It all relates to the collection and use of personal information in a way that is transparent and has been consented to by data subjects.
Interesting. So that's for companies who are starting new systems, new products, new processes. But there are a lot of companies who have systems which we call legacy systems.
Yes.
So systems coming from 70s and 80s or even 90s, and they have grown over time. They were not meant to be, meant for deletion, meant for these the new things we expect in the privacy laws. So how would you recommend or advise them to tackle privacy by design or privacy by default?
And it's more challenging, there's no question. But I always say to them, pick one or two areas that are extremely important to your business interests and to your customers. And start with even one area and take a look at your information practices relating to the collection and use of personal information from your customers. Have you obtained their positive consent when you obtain the information? And probably you have for the first use of the information. But then you need to see what additional uses of that information are being made within your organization in ways that had never been consented to. And even if you can just in that one area try to either restrict the use of the information to the primary purpose or go back to the customers and say, we would appreciate using your information for these additional purposes. We believe they would benefit you in this way. May we obtain your additional consent? So you can start small, but over time, legacy systems have to morph anyway into current day practices. So you might as well start by trying to gain a consented model from your customers, and they will appreciate that enormously.
So manage it in layers, take it step by step, identify use cases, and use case by case, manage privacy by design rather than trying to tackle the full legacy landscape.
Beautifully put, Puneet. That's perfect.
In episode 8, we had Alan Woods who says, "How the hell did it happen?" And we asked him, "How practical is GDPR or data protection for small and medium businesses?"
It requires the kind of information management control that most organizations, most small companies definitely just can't afford. And that puts them in a position where they have a regulation that they cannot comply with because, first of all, they don't know how, and secondly, they probably can't afford it.
Yeah, I think it's both affordability, understanding, and a lot of other factors, and also will, because their priority is towards earning money while this is expenditure, and they are not able to justify this expenditure as something that helps them earn the money.
Absolutely. And that, to my mind, makes it unfair. It also leaves out the idea of personal responsibility and liability, and I'm all for that. What tends to happen is in IT, geeks are the one bunch of people who can create mayhem and then just walk away as if nothing has happened, and that happens too frequently.
In episode 9, we had Debbie Reynolds, the data diva, and the CEO of Debbie Reynolds Consulting. And we continued with question on how can small businesses ensure privacy compliance.
How do small companies who have very limited resources manage this? And what was the biggest challenge, privacy challenge, that these small business owners are encountering? Because they are tight on budgets. They want to go to the market as soon as possible. They want to be innovative, and they want to be so-called entrepreneurial or innovative and fast to market, fast. So what's the biggest challenge they are facing from privacy perspective?
I think their biggest challenges for small companies to really be able to find a resource that is affordable for them. A lot of it is really understanding your own business and understanding your own risks. Not every company needs the same privacy staffing as like Microsoft.
Right.
Obviously. So you don't have to be Microsoft, or you don't have to try to be a mini Microsoft or anything like that. But you want to know, you need to at least have some idea of what your risks are. First of all, what customer data do you collect in the first place? Is this any sensitive information to begin with? Are there people in the marketplace that I can ask about this? LinkedIn is a great place to ask those types of questions, and to be able to ask for recommendations for people who may be able to answer those questions. Maybe you don't need a full-time person. Maybe you need just someone that you can call maybe once a month or something, right, to ask them questions. So there are many different ways to be able to approach this, but you definitely want to be able to find someone that you can at least ask a question. There's some people they're kind of on retainer for, maybe a couple of hours a month for you to be able to touch base with them or have them do like a training. To me, it's a little bit parallel to like cybersecurity in some ways, where you really want to be able to have someone that you could pick up the phone and call, whether you're a full-time person or a part-time person or someone that you just retain, for a couple of hours a month, just to get some idea of what your issues may be. Being able to have that person that you can call before a crisis happens is very important, because they may help you. For example, they may be doing a triage thing with you where they say, okay, here's your high, medium, and low risk.
True.
Let's look at your high risk stuff first, and and figure out what's the best way to mitigate those issues before we go to the medium and lower issues.
Indeed. And I think that's a big challenge for small and medium enterprises. Not only finding the right resource to help them on a part-time basis, because people like you and me help them with that part, but even if you have us as helping them out on a need basis, on a fixed fractional basis, as we may call them, you still need to understand when to call the other person, when to call us, or when a situation warrants. So you need to build in some sort of a understanding of contextual privacy. When is it applicable, when it's not applicable?
Right.
Yeah.
Right. That's a good point. So contextualization of it is very important.
In episode 10, we had Nicolas Castellion, who's a senior manager in Capgemini and advises clients on data privacy and cybersecurity. And we asked him, what is the most challenging aspect about GDPR compliance?
Well, first of all, the bigger issue, and it's also very similar to what happens with cybersecurity, is that the privacy department is a separate department than architecture.
Yes.
So let's talk about a company. Let's be very generic about this. A company that collects data and they sell that data for the purpose of maximizing a market. I know this sounds very vague, but this actually is a very common business model.
Mhm.
Collecting a lot of data for the purpose of amalgamating it and then providing it through a client through a portal. Okay, so there is a lot of data to be gathered. Then you have architects. Architects will be designing the architecture. And of course, I mean digital architects. So they'll be using some framework to design data flows and such. The biggest challenge is that these technical architects don't usually understand the GDPR, and the people who are going to be auditing this architecture don't understand the architecture flows.
Right.
And they are really speaking different languages and seeing different colors. One could be colorblind, let's say. And that's one of the interesting challenges, to see them sitting in the same room and not being able to see eye to eye on what the definitions are. So I would say that defining privacy in terms of digital architecture and information flows, that's one of the biggest challenges.
Yeah. And when it comes to social media, because that's also one of the technological advancements these days, what's your view on social media and privacy? Does that go hand in hand? Is that a challenge?
Right. So that's an interesting one. So social media and privacy. At the end of the day, you get to ask the question: do people care about their privacy, but they still want to use social media, right?
Yes.
So, well, you're paying with your data, right? This is one of the most common misconceptions: is that you using Facebook actually you actually, there is a price tag for your data, and that price tag will vary depending on what market you're in. Somebody in the North American market versus the European market versus, let's just say, South American market will have a different price tag attached to each other. So technically your data has a worth.
Right.
And something that you should know, which should be a main mantra for this field, is if something is free, it means that you are the product.
In episode 11, we had Saurabh Gupta, CEO of Plum Cloud Labs, sharing with us how he believes clarifying what is the core of implementing your GDPR strategy or privacy compliance strategy.
One of the biggest challenges that we hear consistently from our customers is understanding what do they really need to do. You see a whole lot of suggestions from all these other interested parties, including us, right? And they are all along the lines of how do your data security initiatives tie into privacy? How does archiving tie into privacy? Like literally all of these other ancillary industries around it. There is so much noise in this space that most customers spend a huge amount of time just figuring out what exactly do they need to do. right? There are laws and regulations such as GDPR and CCPA, and there is some level of clarity around what needs to be done. But when you think of it from an implementation point of view, they're all so subjected to interpretation, right? How my organization sees it, how a regulated industry customer sees it versus a retail or non-regulated B2C type business sees it. And the challenge for most customers is to really boil it down to the essence of what data privacy should mean for their business and to materially implement it.
So cut the noise and find out clearly what you want to do and how you want to do.
Less PowerPoint, less documents, and at some point more real working software and processes.
Yeah, and I think people are also struggling to interpret what the law means, what do they want to do.
Absolutely, and I think the kind of work that you're doing in that space, Puneet, and the book that you've written, I think those are the kind of things that industry really needs more of on the thought leadership front of this and on the education side of it. And then what it needs is more of, once that what is more clearly defined, it needs more of that how, which is well engineered software, well thought through and implemented business processes, more training around those things.
This was part 1 of Data Protection Day special in 2021, bringing to you the top experts, top industry leaders and their views in Fit for Privacy podcast. And for another set of people, that is from episode 12 to 22, we will have part 2 coming up next week. So thank you so much for listening to this. We really appreciate that you take time and listen to it. And if you need any help, do not hesitate to contact us. And more importantly, please do click like, do comment, and do share it with others. And if you have not yet subscribed to this podcast, please do it, and also write a review, because when you subscribe and write a review, subscribe helps you to be notified about new episodes, and comments help others and help us in terms of getting to more audiences. Help is really appreciated. So till next week, thank you so much. Stay safe and enjoy.